Morning.
Hey, good morning, Sarah.
Janet's gonna be a little bit late.
Hey.
About 5 minutes, I think, is her ETA.
That's more company today in the.
Two
Two of us, yeah.
Thomas is here with us. Getting room visual? Yes, we're getting room visual.
Oh, fantastic.
Good. Oops. Somebody dropped the loaner off last night. Was that Kirsten on her way through or?
It's probably Kirsten or
It was-
Brooke.
It was Brooke.
Oh, it's Brooke. Okay, great. It still had your name on the computer, Sarah, so I was hoping that you hadn't gone all the way back down and came back up.
Oh, no.
She was
I think
just the
they're-
last to log in.
Yes.
Yeah.
No, the sale been set up went pretty well, except I apologize, Alex, you and I probably should have flipped. When I set up the room, I was trying to set it up so no one would trip on cords going around the table. And I think I probably should have been under the monitors because your neck must be a little bit.
Well, thankfully, the Northwest Regional Planning Commission team provided a hard copy of their presentation. So I actually did not look at the monitor during their presentation. I was able to just look at their hard copy. So no, my neck is still in good shape.
Good. So as soon as we get another board member, we'll start right at 9, if possible.
Right, get my record thing ready.
Morning, Kirsten.
Good morning.
Make it home safe.
Yep. You guys?
Yes. Long day for you, I
Yes.
can imagine. But nicely done.
Well,
Kudos.
and Janet must have been up really early.
So Janet's en route. She asked that I start the meeting. It's right at 9 o'clock. We have a quorum. So is everybody okay with us starting?
Sure,
Mhm.
go ahead.
All right, and we're recording. I saw that.
Oh, did it go? Give me
Well-
1 second.
I haven't seen it yet.
It says, yeah, okay, it's recording. We've got confirmation
right.
on this side.
Then I'll call the land use review board meeting to order. Sarah Had, vice chair acting until Janet comes as chair, present. Alex,
Alex Weinhagen. Hello, everyone.
Kirsten,
Kirsten Sultan.
and I see Brooke just joined. Brooke, would you note that you're present?
Brooke Dingledine present. Sorry, I was having some connection problem.
All right, thank you all. Any agenda updates? All right. Any opportunity for public comments on non-agenda items? We have Thomas and Annette that have joined us. Would either of you like to offer anything to start this morning on something that's not on the agenda?
No, thank you.
Annette? All right, we're not hearing from Annette, so I think we'll continue on. I'll just say, just in terms of a public comment, nicely done on the NRPC pre-application meeting yesterday and site visits, Kirsten. That was a lot of ground covered in a short period of time, but very well done, Kirsten. Thank you.
Oh, thanks. A lot of information.
Yes, a lot of information coming at us. So
Mhm.
the other thing, just until Janet comes, I'll just say in terms of announcements is I have a request for an extension on comment for the CCRPC plan, and I will grant that as a blanket approval for the up to 10 days for all parties. I'll put that into writing today. All right, well, I can't stall anymore, but Brooke, Janet should be joining us shortly, but would you like to start on the Appeals Day report?
Yes, I would. Thank you.
Thank you.
So, after our last meeting, and our discussion, particularly with Alex, and the timing, and he was concerned about, are we just doing the same process that the court is? It's about what is the review that we are performing and how quickly can we do it? And what we have been struggling with, and what I personally have been struggling with, is that my concern that we're building a system and I'm not sure that we can deliver, a significantly shorter process. So I've been very talking to a lot of people and trying to delve back into how the environmental board worked, because it was, while there are different comparisons of how much processing time was necessary, the bottom line was you were dealing with a volunteer board, not a full-time board. But in any event, I went back to the beginning to think this through and went back to the report that was issued in 2017, I believe it was, which was the Next 50 Years report. That was a committee of legislators, including folks that are now in the legislature, and the evolution of this is Act 181. And I went back to that report to look at what their thinking was about the road ahead and what eventually led to the statute that we're trying to implement right now. And it talked about creating the appeals, a LURB under a different name, but it was as an appeals board. And it discussed everything that we're discussing, maybe not as in detail at all. But the standard of reviews that they were looking at were on the record and de novo, and they decided to keep de novo the way it was. They were not suggesting some hybrid. They were choosing just between the two alternatives. And they were saying, we don't want to go to on the record because that will formalize the district commission below and people will have to lawyer up. So the upshot is that I believe that we should eliminate discovery. The environmental board did not have discovery other than you had subpoena power to bring witnesses to trial or documents, that kind of thing. But what we've been grappling with is we don't want to be an appellate legally based board. We want to do primarily the same job as the district commission in the Act 250 process. We're the double check. We're the ones to come to, and you get a hearing to make sure that that decision below, which was by a citizen board by design, but that it's legally up to snuff, or that the concerns that are brought up on appeal are looked at. Now, what we were considering is we don't want to broaden the process. We want to refine it and have it more like a funnel, because the only thing you do on appeal are the issues that are of concern that are actually appealed. And in that process at the environmental board, and the other comments, like Janet was talking about, we should be doing a hearing, like a normal, like a DRB, only this is, a more complicated statute, instead of like sitting in judgment or trying to figure out whether or not what happened below was right or not. And so I have come to the absolute conclusion, the way to go about this is to reinvigorate the same mechanism that the environmental board was using, and that is a de novo review of Act 250. on only the scope of the issues that are raised on appeal. Forget about records and all of that. We can take the Act 250 database as a record, so that people don't have to put that into evidence to us. But I think that we should follow the same model that the environmental board used in this regard, because I believe that is the way that we will truly be able to reduce the processing time so that we don't get diverted on, the sideline, discovery and discovery disputes and motions about they didn't turn everything over to me. I think there's more. That's where some of the motion practice comes and the further delays. And now, and I've talked with other lawyers about this who practiced back then. I've been making the calls, really trying to vet this very quickly through people that I know have practiced and know what the process is and will understand the nuance of this. And the concerns were, we don't want trial by ambush. Well, what about at the district commission? I'm not saying we're going to set up a trial by ambush, but what we're saying is you come and you put your case on, okay? The way that we prevent trial by ambush is we require disclosures. And so we'll have a pre-trial order, and I will work on this weekend to create it as the example of how the actual board will proceed. If there's an appeal filed at that time, and this is in the rules that I've drafted and already slipped into the addendum or the appendix already, they have to, in the notice of appeal, like Rule 5, explain what their statement of issues are, statement of questions. And we're also asking for preliminary disclosures on witnesses and experts. So in that actual notice of appeal, which will have to be filed 30 days after the actual decision is rendered by the district commission, then the notice of appeal has to be filed, and not only the statement of questions, but you're also going to tell us what your evidence is in a very preliminary way. But then we have to pick a time period, but say 30 days after the appeal is filed, everybody needs to get in their witness lists, summary of what the witness is going to say, which can be very summary, but you need to tell us, appellant, what this person's topic and what they're going to say is. And it can be 2 or 3 sentences, but they need to identify who is this person and what are they going to talk about. What are they going to address in the hearing on appeal? If there are expert witnesses, they need to give us an expert disclosure, and an expert disclosure is, this is who I am, these are my credentials, this is my opinion, this is what I base it on. These are the facts that I used to apply this standard, engineering standard, whatever it might be, to this project, and now this is my conclusion. That we're not asking for pre-filed testimony of fact witnesses, but experts have to give their report. And it can be in pre-filed testimony format, it can be in report format. Who cares? We need to have that ahead of time. That's what you get ahead of time. You know who's going to testify, what topic they're going to talk about, what the experts are going to say. And then you show up for your trial, like Janet was saying. It's like, conduct the hearing and get all the information, and then we will make a decision. Now, it's those disclosures that supplement for any kind of discovery that's needed. If there are some kind of extraordinary circumstances or whatever, at trial, if something happens where it's a surprise, you can remedy it by allowing more time. You can say, put supplemental information on this, or we'll hold another hearing. hold, a hearing for that one thing in 2 weeks or something like that. Now, I know this sounds like a monumental change in a way, but in fact, I don't really think it's that different because the parties are going to bring us all the record, or we can take the Act 250 record, to save time. We can, decide anything that is put in, either the record that we pull up or the information that is provided before the hearing. The board members will be able to review so that we're not walking in cold to a hearing. And then they supplement by testifying at that point. And that's when cross-examination happens. So that everybody, if it's, the applicant and a neighbor is an appellant, the neighbor gets to cross-examine the, the developer or any of the witnesses of the applicant. And some people are uncomfortable with that. But we are trying to make this an expedited process like it was always intended. And I think that this is the most promising way for us to be able to say, we have a different system. We're not just doing what the court is doing, hoping we can do it faster. We are changing the system. And to me, discovery is the biggest problem in litigation generally, but it's seeped so much into the environmental, appellate situation in court. Like I've said this probably ad nauseum at this point. I think that it turned into regular litigation and there was no expediting or efficiency. I do want to say, and I think it's important to recognize that the court has in fact been very active in trying to speed things up and being more expedited and efficient. And I think it has made a difference. But putting that aside, I don't think that's I think that we can help the system. Act 250 was originally intended to and should be within our bailiwick. I feel very strongly about that as well. I don't feel like I need any kind of minority position or opinion. If we do it this way, I'm not saying I need to do it, under a different rubric, but this is what makes me feel that I can, in all good conscience, say this is an alternative that I believe will in fact be preferable, faster, and will accomplish the goal that the legislature is looking for without compromising due process. It's slimming down process, but it is not eliminating it. So what we would be looking at is, and draft 3 is still half baked for some of the things that I wanted to address, rewording and rewriting to make things sound a little bit better and not so much like an outline in those recommendation sections. I still am working on refining those and boiling them down to the essentials. They are very lengthy and very structured and repetitive. But other than that particular thing, section, let me show you what the chart would look like if we change.
So I'll just note that Chair Hurley has joined us, and I'd like to turn the meeting over to her. And I believe there are hands raised, Brooke.
Okay, Kirsten, do you have a question for Brooke?
Yes. So can you elaborate a little bit on the circumstance under this model with no discovery? What would be the circumstances where appellants or participants could qualify for additional time to make known their experts and the scope of what their experts would address? I'm just trying to understand sort of like the scope and relationship of that content as part of a district commission review versus, you know, at a board appeal level. So what would be in your mind, like the circumstances that could justify that people might, in some cases, need more time to identify their, you know, additional experts or, you know, content that those experts might bring forward for, you know, as a component of a board appeal. Could you talk a little bit about that?
You know, the best person to talk about that popped in a moment ago or a little bit ago, Annette Smith of Vermonters for a Clean Environment. Because I know often at the PUC, she assists folks, but you know, in my mind, yes, I'm very concerned about the idea that, all right, the district commission level is supposed to be neighbors making a decision. I don't mean next door neighbors. I mean, you know, the citizenry making a decision, and it's not to be as formal. So normally, expert reports, you know, they may or may not be hired by that point by someone who's not the applicant. And, or they may wait until a decision is rendered. And then if they need if they need an expert for the appellate level, obviously that's the situation that's possibly a timing concern, because frankly, there are some areas of expertise that are extremely difficult to get an expert, if you can at all, or if you can afford one. And forget about the engineering kinds of things. I mean, aesthetics experts are charging so much money. I thought I was in the wrong line of business when I was a lawyer at times, because, you know, the Creechy analysis can be performed by an expert or a non-expert. And the question really is, what is the perception of the weight that's given to the opinion? If you're a neighbor saying you're going to spoil my bucolic view, people tend not to listen because they think that you're biased and you're not an independent person. So that's why even that kind of criteria has expert testimony, because you know, there's a notion that landscape architects, you know more about what people notice and what they don't notice, you know, in a view shed. Now, I don't necessarily think that an expert is required, and I think that we're at a point with particularly that criteria that I've seen, you know, more recently litigated at the PUC, where it's a complete waste of money. And I think, for example, a site visit would be the best thing for the board to go to, as opposed to listening to a bunch of experts, you know, argue back and forth. So, but your question is how much more time? It depends, I think, is the answer. We give some more time, but you know, we can't hold up a system just because somebody is around shopping for experts. And we also have to recognize that, okay, 30 days is a quick turnaround, sure, but how much time has already elapsed where they could have been working to get somebody on board, yada, yada. So I think what we have to do is, those are the factual situations that we can't necessarily plan for. We can build in, and if you need more time or continuance can be requested, please ask for them, you know, a week before the deadline, or, you know, some time period before the deadline. And they're just going to have to ask for more time based on the actual factual scenario. And the board will have to make that judgment.
So it could be, yeah, I was just trying to understand the circumstances in which someone might qualify for more time to develop that expert information. And in my mind, it's not even about, is it the applicant or an opponent or some other participant? It could be any participant that may, you know, an issue emerges, there's a decision at the district commission level, and then when something goes on appeal, the decision is made. We really want to have additional expert, evidence and information brought in, and maybe the circumstances could be something like, I've asked these 4 entities for a proposal and none have responded yet, or, there just could be some situations where the person or entity would perhaps qualify for more time, but
Yeah, I think you're gonna
So-
have to take that on a situational
yeah,
basis.
case by case.
Yeah, because,
Some degree.
it will depend on what the criteria is, how important an expert would be to that criterion, and what the circumstances are.
Yeah.
Because, I mean, I would have less concern about giving extra time to an applicant. You mean, you didn't have your act together when you came to begin with? I mean, normally they would be planned they would know what they're going to do if they get denied, or if it gets appealed after they get a permit. But my concern really about that situation is more about people who don't necessarily have money or, know about experts yet until they go through the district commission process and go, oh, there was an engineer guy that, testified, maybe we should have had one of those, that kind of thing. But look, this is supposed to be, even court was supposed to be a summary process. They've already had their day before the district commission. This is a safeguard. You get another bite at the apple.
Alex,
Brooke, you drafted up and provided to us in this third draft the draft rules, board rules for appeals as one of the appendices. And I'm wondering, per Kirsten's question, if you could just, without a lot of descriptive language, but just sort of numerically walk us through what the time horizons would be for an appeal of an Act 250 decision from a district commission, like just using that one example. So I see that there's 30 days in which to file an appeal. And I see in your proposed rules, there's 21 days from when the notice of that appeal goes out to interested parties, for those interested parties to express interest, to be involved. So I see I think those are the first 2 steps. There's 30 days and 21 days. There's also, I think, a 14-day period for cross appeals built in there as well. But could you just walk us through that? Because that might help answer Kirsten's question about, how much time is built into the system already, and how often would we need to be granting potentially extensions?
Sure. Well, you've probably done more than I than I can think of at the moment. I mean, yeah, those are the primary. The docketing of the appeal is the first thing that has to happen. So you get a notice of appeal, and then you got to let people get that served to them, and then they get the opportunity to respond. So the first month and a half potentially depends on whether a cross appeal is filed. So you file an appeal and I go, oh, they didn't raise that other issue that I was going to appeal on. So you file another appeal within 14 days. So the longest time period, those 2 things combined, is like 45 days before you know who is in the case, right? And then the question is, what happens? Well, you're going to have an immediate pretrial conference. And that happens at the court, but it would also happen at the e-board, and to organize everybody and set the schedule. Because it's all fine and good to say, oh, we're going to have a hearing in 30 days. This is the date. But you need to understand what people's schedules are and not get buy-in, but figure out when this can happen, as well as what dates are available for the hearing to begin with. The board is going to have, this is a hearing date on, scheduled on our schedule, Thursdays or that, or something like that. And so they're given that slot. And before that happens, there's disclosures of evidence. And in my mind, that needs to happen within 30 days of knowing who everybody is. And then you have your hearing. How much time between the disclosures and hearing? Like, you need at least 2 weeks. So these time periods we need to decide on. what, do we have a pre-hearing conference within 30 days of knowing who's in? 15 days? Have any preference on that? And then once you know all the evidence, how many days? 2 weeks? A month? I think because we're asking for information right up front, what's your preliminary list of witnesses? I think we have a conference within 2 weeks or a month. Let's say 30 days for the conference to happen. And after the conference, you will have 2 weeks to give us your list of witnesses and evidence. And then 2 weeks later is the week that you'll have your hearing. That gets them in and out in 90 days, or trying to get it in and out in 90 days.
I feel like first of all, I need to read this. And I have not had a chance to. So, and the other thing is, I also feel like we should have maybe set hearing dates at which we, on a regular basis, this is when we do appeals of, whatever. And that we shouldn't have to get 20 people to agree on a date. That we say, this is the date, you need to be there. If you have a really compelling reason that you can't be there, you can talk to us. But I don't know how important it is to have a pre-hearing for scheduling. I think we can just schedule. I don't know that yet. I haven't read this yet. I just feel like I need more time to take in the details here before we can say that this is ready to be submitted to the legislature. Sorry to say, but
Now,
I
and
just
this is
feel
a little
like,
bit of a U-turn right now. And I would not propose it if I didn't think that this is really a much better idea.
no, I like where you're going, Brooke, and I don't think it's that much of a U-turn. I think what you're doing is you're trying to come to a consensus, recommendation, right? You're hearing from board members, and this is a way that takes into account what we've all been saying together. I just feel like I don't see how I can be comfortable submitting this on Monday. I can probably be comfortable submitting it next week, but I'm not sure that I can do that on Monday.
Yeah, and
Alex.
I agree. This
Yeah.
is too much at the last minute. But I feel like it is doable within an extra week.
Yeah.
If we could have, maybe get in touch with the committees and say, we're coming down the home stretch, but we'll have it either by Friday or the next Monday or something.
Yeah. Yeah. I would feel comfortable with that.
That's still
Yeah.
before Thanksgiving, and
Yep.
the deadline, the December 1st deadline, I know is looming, but
Yeah. Alex?
Yeah, so I agree. I don't think this is a U-turn, Brooke. So don't feel bad about that. I think this is a synthesis and some decision-making, policy decision-making or recommendation. So I think it's fine. Janet, I totally happy to, delay a week so that you have more time to read it. But I would tell you that where I focused my attention in the last couple days was just on that appendix, the one with the draft rules. And it's
Right.
actually
That's
not,
what I've
it's
got
not,
open right now.
yeah, it's not, I thought it was going to be much more. It's not that much to read.
Yeah.
It's pretty straightforward. And as far as the substantive change, Brooke, that you've been describing about the no discovery, like I would have been recommending that from the start if I had had your acumen about, how the process works. I don't think that's necessary. I've never thought that that was a necessary component. So I'm happy that you've come to the place where you feel like it makes sense based on the e-board's past practice and the like. So again, not a U-turn, just, good decision making at the end, I think. So yeah, I'm happy to have more conversation today. I have a few comments and questions on the appendix that you added, but nothing truly substantive. But I'm also happy, Janet, if you need an extra week to delay. And I don't think we need to worry about touching base with the committee
Right,
chairs.
neither
Like
do I.
they're not
based-
gonna, Monday, Friday, the following Monday, no, there are no legislative cops walking the beat who are gonna come give us a ticket because we got it in 6 days or 7 days after the statutory deadline. So I think we just finish it up and submit it.
Yeah, I think we could discuss on Monday and get a feel as to, which day next week or whether it should be Monday the week after. But yeah, I'm not afraid of how much reading there is. I just want to understand this process. So is that Pete, Thomas, or
Yeah.
Rachel?
Yeah, that's me. I would just say, we should at least, reach out to, Representative Mahali, just as he's been following this. This has been, a particular interest of his. We should just let him know kind of what our time frame is. I don't think there'll be any issue there, but even just a quick email, I'm happy to do that or let you, Brooke do that.
I can do that with maybe Brooke or maybe Brooke and
Yeah,
I
what,
can.
I've been in touch with him, so I
Okay.
can send that. Not a worry.
Okay,
I'll
great.
see you, Janet
Okay, thanks,
and
Brooke.
Pete and Pete.
Yeah,
And
thanks.
Sarah?
So just a couple of things. So it sounds like the rules that you sent out, the draft that you sent out, are still going to change. All right, head nod. I think that's going to be a lot for all of us, just even between now and Monday, with everything else going on to get through in terms of substantial changes. And so I just want to have a quick conversation about how best to do that. If instead of having like a whole different version 4, what have you, if there could be like a highlights or like a change pages call out or something like that to focus our attention on. For those of us that were striving to read through the rules, the draft 3, and then there's going to be new ones. And then I think the other thing that I want to be cognizant of is the pileup effect. Is we're also under deadline under Rutland Regional Plan to get that out. And we have a couple other regional plans coming in. And so absolutely we shouldn't act on these things unless we're ready. However, I think that just to have that discussion with the board here today, if we are going to be asking for an extension on the appeals and having to continue to consider that as well as the Rutland, we might want to ask Rutland Regional Planning for an extension to be able to facilitate everything and give everything the attention that it's due.
Yeah. I sent a draft for the Rutland response to you late last night. I hope you'll have time to consider it before Monday. And what I would be working on in the interim is fitting that into the shell that Rebecca has worked on for us. So same thing. What you have right now is not the final format. So you will want to see it again after Monday for sure. And we do have Thursday as a placeholder for another board meeting. Maybe we could look at both this and the appeals on Thursday.
If you wanted to not look at the appeals report Monday and do that Thursday, stagger them, don't do them on the same meeting. And I have there's not that many changes with version 3. It's, and we should be looking at the red line strikeout. I just didn't know how to PDF the red line strikeout version. But we can circulate the red line strikeout version because you don't need to reread, most of the report, the appeals.
Kirsten,
So I agree, we will definitely benefit from more time to submit the appeals report to the legislature. And we were already working on an accelerated schedule, so I think it's reasonable to take an extra week or whatever time is needed. I just have a quick clarifying question about the Rutland pre-application, draft recommendation, Janet, that you mentioned you shared last night. The template document that legal is making available to us to use, that's just changing the format, right? Like the content of what you shared in terms of like, the substance would be the same. It just would be presented in a different format. Is that correct?
yes.
Okay, thank you. Look forward to reading it.
Annette,
Yes, I have some other comments, but on the issue of contacting the legislature, just to give you some example, the Public Utility Commission had a deadline of November 1st to get a draft rule into 2 committees. And the day before, they sent a short letter saying, we're working on it. We'll get it to you by December 1st. And they submitted it 2 days ago. So just to give you a little view of how another state agency deals with the legislature. So in other words, you might say we will get it to you by the end of the month, but you might get it to them sooner. So I don't think you need to feel like you have to pick a date that you're going to send it. Just give them a range or something. I still think you should talk to the representative, but that's what I'm seeing happen.
Yeah. And I've already put out a feeler and gotten feedback that it's not going to be a big deal if they don't get it on Monday. So thank you, Annette. Anything else on this draft that Brooke has presented us? Pete?
Yep, sorry, the cursor wasn't working there. Yeah, we got a public comment here.
Oh, okay. Go ahead, Thomas.
Thank you, Thomas Weiss here. I appreciate the changes in draft 3 relating to portions that I had mentioned at your meeting on Monday and followed up with a letter. However, there are still 2 statements in draft 3 that are not supported by my research into the history and evolution of Act 250. On page 12, it incorrectly names Act 115 of 2024 as a Permit Reform Act, and I don't ever remember having heard it called the Permit Reform Act. So I suggest changing Permit Reform Act to Act 115 of whatever year that was, 2004. And then on page 24, the report still states that the Environmental Board heard all appeals from 1972 through 2005. I did submit research from the Act 250 database, and I request that the 1972 be changed back to 1970, which is when they did hear the first appeals. And then I also remembered that the Environmental Board did not hear all appeals during that period. There was a period from 1973 through 1985 that an applicant who was appealing could, and the word was remove the appeal to the initially county court and then the county court successors over the years. So I would suggest dropping the word all and changing 1972 back to 1970 as simple corrective measures to get more in line with the facts, as I discovered them. If there are contradictory facts, I'm willing to listen to them, but. So anyway,
Yeah,
that's my comment.
I don't have contradictory facts. I ran out of time, Thomas, in the middle of your memo. And my placeholder is page 12.
Okay.
So I appreciate all of this. I just didn't have time to finish all of the comments in the time that we had with all of the other tasks that we are working on. So absolutely, I'm going to pick it back up. And actually, I think I'm rewriting that entire section based on the information that you provided. So you'll see a new
And-
paragraph basically in that.
Yeah.
So.
And
okay.
I gave Brooke my hard copy comments last night, so there may be a few changes here and there. So I think there'll be a draft 4.
Yeah, and I think, how about this as a proposed way forward? If I can get the board a version 4 that I think will be where I think that the report needs to be on Monday, I could work on that over the weekend. And we plan on being able to review that individually during the week, and then on Thursday, I think having the meeting, and if we can't get where we need to be, finish it up the following Monday.
And I would still like some time on Monday to discuss, maybe you could present on screen what you've got and we could discuss a few pieces of it, just to get some of it, taken care of. Alex.
Yeah, so process-wise, that all sounds fine to me. I am sensitive to Sarah's point about like which version are we looking at, which changes have been incorporated into which version. So I have a lot of trust in my fellow board members, so I'm not going to be too concerned about that. But it is helpful sometimes to have a track changes version, right? So that we know, what from draft 2 Brooke changed to address the comments. But I have actual questions about the new information in this draft. And if I could just walk through a couple of them, these are all related to the appendix on the board rules,
Yeah.
which I think was, the big addition to this draft. So Appendix
Want-
B.
Want me to
So the
share
first one
that
is-
on the screen? You want me to share it?
You don't need to share it. I'm just happy to note, what those are. So the first one is that this procedure contemplates municipal panels when there's an appeal from a municipal panel, having them submit all the evidence from their review to the board. I have some concerns about requiring the municipal panels to do that, but I don't see a better alternative. So I just wanted to flag that, like, as a former municipal official, that's going to feel awkward because the current process with the court, there's no such thing happening, right? The current process with the court, the appellant submits whatever they need from that original review into evidence for the court to consider. And so the burden is on the appellant to produce, not the panel that was where the appeal was taken from. But in our system, like, I think you're right. I think we need all the evidence and we want to have some ability to look at it and not have to start from scratch. So I just wanted to flag that. That's all. I think we'll probably hear some municipal officials being a little concerned about how they can do that. But moving forward, my understanding is that under the open meeting law, all municipal panels should be creating a recording of their meetings. Right? I believe
Yep.
that's required. So
There may be a few
Unless they get
exceptions,
a waiver.
but yeah.
Well, you've got a section in there that talks about transcripts and the appropriate municipal panel making those transcripts upon request by an appellant, and the appellant paying the deposit and so on and so forth. And I think that's way too complicated. I think if we're going to have municipal panels turn over all of their materials, they should turn over their recording as well. That should be public, whatever format it's in. And then the burden should be on the parties to create the transcript for the portion of that recording that they think is relevant and needs to be, in words versus a recording. So I'd rather take the burden off of the municipal government and put it on the parties to the appeal to get the transcripts done, given how problematic that process is. Next comment.
All right, wait. Before you go on, I want to
Yeah.
talk about this because it's really important. This is like the big, not the big surprise to you, but so, the Act 250 thing, I think we should go back to de novo. Now, let's talk about the municipal appeals because if we're not giving discovery on that either, there is also an argument to go back to the status quo for zoning appeals. So if you are not an on-the-record appeals town, and there are only 5 or 6 of them or something, you get the normal de novo review, like we'll be doing the Act 250 de novo reviews. So if we were gonna look at the new chart, this is a red line strikeout version. So if we change we're taking discovery to none, but if we change this standard of review back to de novo, and the next question is, do we do the same with municipal appeals that are not on the record, that have not elected to do that? Because again, it's like, look, the appellant brings to us what they want on the record, and the appellee brings what they want us to see on the record. Why put a different burden on the town? Just keep it the same that it is.
So I hear what you're saying. And this was going to be another comment based on the prior conversation. While I very much appreciate the no discovery, I think that makes sense. I still like the hybrid review. I still like the ability to, this is the wrong terminology, but to essentially give some deference to the prior panel's decision by incorporating the evidence that they looked at, and by making our process hopefully easier because we don't have to look at everything fresh again. We can look at what was presented, and then it's just a matter of only new evidence, that helps flesh out your statement of questions needs to be submitted. So I'd like to keep the hybrid review, not flip to de novo, but with no discovery. And with that in mind, I would like the recording, which should exist, to simply be part of what the appropriate municipal panel provides, and then keep the burden on the parties to go through what is an onerous process to get a transcription if they feel it's necessary. And hopefully it won't be necessary because we'll have all the other evidence. And but that's up to the parties to bear that burden.
I mean, I would
Let me-
not to have to get a transcript unless there is, unless somebody's pointing out that the rest of the record is inaccurate, and this transcript will prove it, something like that. But can we go to Sarah?
Let me just say one thing about it, on this deference issue. We could build in the standard of, do a de novo review with due consideration to the decision below. We're going to be given the decision below anyway, and the court reads the decision below. And I think in reality, that's the tiebreaker. If it's like, don't know which to decide, and they go with the decision below. So we could do de novo. That's like what evidence that you take, which that's where we are anyway with this hybrid kind of. So if we just keep the status quo, but then actually acknowledge that we're allowed to give weight to that decision below, like at the PUC with town recommendations on preferred sites for renewable energy. There's due consideration, and then there's substantial deference.
Substantial difference.
I like the due consideration. I haven't, it's not clear to me why we would jettison the concept of the hybrid review that we talked about earlier. So My fear with de novo is that the assumption is everything needs to be presented again. Nothing gets entered into evidence except what the parties enter into evidence. And that just seems, I liked what we had previously discussed better. That's all.
Yeah, well, and we can figure that out, because see, in Act 250, we have a database. We know we have all the stuff collected in one place. With the municipal side, it's like they have to get it together and give it to us, right? So it's
Which is-
really a question of
yeah.
like, whose job is it to give us the stuff? Kind of, in a way. It's like, do we want
I think
to
Alex is
require
suggesting it
town-
shouldn't, yeah.
my concern is that we're requiring towns to do something that they didn't elect to do because they don't want to have to
Right.
be an on the record town. That's my
Right.
concern.
Right, which is what Alex is concerned about too. And so I think it needs to be on the appellant or appellee if they think that that is necessary information to provide us. Sarah?
So, thank you, Brooke, for I think coming up with a more comprehensive solution for us that sort of gets us all going more in the same direction in terms of trying to improve timelines for appeals. It's a different process. The rules are still in flux. I wanted to ask something that we haven't yet talked about today, but was another place that we were stuck, which is staffing and what we're going to need. Do we need another attorney? Do we need just another tech or somebody else of that nature? With the route that you're thinking of going, what are your thoughts in terms of staffing levels?
So for becoming an appellate board, I think lots of people feel strongly that we need a dedicated clerk, tech, somebody in charge of the docket. Okay. And that I think is essential no matter which way we go. And, you know, because one of the other issues is this board doesn't have an admin, right? And so while we can put a board member in charge of the case, like as the hearing officer to move things substantive, you know, dealing with higher level things, not just the organization of the documents, I think that we have to have that dedicated person for that. And when that person is on vacation, we can have somebody else fill in. But I think that person is really essential. I don't think that we need an additional attorney unless we were to go beyond Act 250 reviews. I think the repurposing of the Act 181 lawyer, I know that there will still be Act 181 tasks even after two years from now. But I think the combination, knowing what the appeals levels are today, I think that we're okay not adding a lawyer if we're only taking Act 250. If we were to go beyond Act 250 and we would be taking appeals of zoning, I think we do need another lawyer. And there are opinions that we need more than that sooner, and there are opinions that we should be able to do this without anybody else. So I'm trying to strike a balance, but of course, all of this, and this is why I feel more comfortable with this sort of like 2-year check-in. If we were to take Act 250 appeals, that's the moment in time to say, and what could we do further? What's happening with zoning appeals, housing appeals? You know, we could be making assumptions that get blown out of the water. This could be so successful, there could be no appeals. This could not be successful. There could be many.
Annette?
Is this the appropriate time for my comments?
Sure.
Okay. So on the report itself, I have 2 minor comments. One, it could either be at page 1213 or I think page 20. And could be in a footnote, but in the section about ANR appeals, it is an outlier that renewable energy appeals of like stormwater permits at ANR actually go to the Public Utility Commission. it's the only thing like that. It's an outlier. I think it's ridiculous because the PUC defers to ANR, so now they're supposed to hear the appeals to of an agency they defer to. But I think that if you are providing the legislature with an overview of the appeals process and addressing ANR permits, it is appropriate to note that there is one exception. And I actually would like to see the legislature undo it. I understand why it happened, because it was when Meredith Wright was the judge and she was taking too long in a case and the developers got upset and they got it moved to the PUC, which then did hear one. So it's only been one. My other comment has to do with a footnote on page 38, and it refers to some members of the steering committee, and I don't know what the steering committee is. It probably means the stakeholder group, but I don't know. It's the only place that that term appears in the document. The other things that you've discussed today, I've been involved in this week in at least 3 different scheduling things for PUC cases. I've also been watching developers, as they say, weaponizing discovery. So I am very supportive of eliminating discovery. It is used to for attorneys to gain advantage over pro se parties, and it's not necessary and is very stressful. On scheduling, as we were dealing with today, a case that's going back and forth between developers and others, it would be nice if the PUC adopted a presumptive schedule or some kind of scheduling template with all the anticipated steps in each type of case, because everybody just winds up reinventing the wheel and arguing back and forth in every single case. So there's a constructive suggestion that you outline all the steps and then give that as a template to people. Janet, regarding the idea of saying this is the date, I mean, the PUC does that. They do schedule things that sometimes attorneys really can't do. But in my observation over the years is that especially the state agency people, they take vacations, they take paternity or maternity leave. The state agencies are overwhelmed. And so if they are going to be parties in a case, they might not necessarily be able to jump to something. They're regularly asking for extensions in PUC cases and also changing deadlines. Attorneys have their own thing. I think there needs to be a little flexibility in it. Yes, you can set a date, but you also need to be aware that people's lives are very full. Let's see. There was one other thing that you all discussed I wanted to address. The idea of de novo and hybrid. So I was involved in an Act 250 case. This is nothing current, where the developer, the permit was issued. The developer didn't like the conditions of the permit and appealed. And I just couldn't believe that everything that happened down below just vanished and it all started over new. And it just made no sense to me at all. And it still makes no sense. So the issues that were appealed were somewhat limited, but I think it is important. I don't know about the due consideration standard of the permit decision down below. I mean, I just would like to see the what happened down below be available to the court to consider and for parties to reference if they want to, instead of having to do it all over again. And on the subject of transcripts, that's becoming an issue in these cases. I attended a scheduling conference yesterday, I think, or the day before, in a PUC case, and they are no longer using court reporters and they're going to be using AI transcripts. Now, I have heard there are real problems with AI transcripts if you get to the Supreme Court level and the transcript isn't good and they say, well, it's certified. So in terms of sending something up, yes, recordings are good. What I've seen happen in PUC cases is where citizens that I work with want to reference something that happened in their municipal body or somewhere, that they will do their own transcript and provide the video. And then if anybody wants to ground truth it, they can. And so that the person who does the transcript or who provides it is the witness that's sponsoring it, but that it is something that is not required. And so it addresses the problem with bad video and bad audio and transcripts. And no, it's not on the record and you're not requiring a transcript, but that one can be done for certain sections that may have had statements that are relevant that can be used above. And I think that covers pretty much everything that I wanted to. Okay, thank you.
Thank you. Alex?
Yeah, just seconding what Annette just said about the transcripts. I really think we need to not worry about them as much. Moving on, Rule 42 in Appendix B, Brooke, is the last one that I had a comment on. And that section talks about a 7-day automatic stay. And I just wasn't clear why that is necessary. I'm not convinced that that is necessary, even if it were part of the e-board rules from way back. Do you have, I don't want to put you on the spot, but do you have some sense of why that needs to be in there?
Because I just copied what we have.
Okay.
And
Yeah, so
honestly, stays, and Jenny's not with us today. Stays
Yeah, she is
are,
actually.
oh, she's there. Hey, guys. It's really complicated. You know, we had a recent case where we were asking for one. It's a really complicated area to understand.
Yeah,
So
so you understand my concern is not about complications, because I like simple. It's about the timeline. And wherever I see a place where I don't think we need extra days, I want to cut it. And I think this is one we can cut. Stays can be requested. I don't think they need to be granted automatically in any case.
let me get with legal on it, because it's just something that really requires a lot of attention and thought to understand. So I was just keeping the status quo because I didn't want to put my foot in that water.
Yeah. So do we feel like we need more discussion today on this particular draft as a board?
Let me, I would like to know where the board would like to be on the municipal standard of review, whether we can articulate it as de novo with the with the recording, and that could be used. And we take whatever people want for below, only on municipal. Obviously in Act 250, we have the whole record already assembled, but do we want to switch to, I think it's cleaner and easier and less complicated sounding if we get away from the hybrid standard that we created. I think de novo is known to people and they know what to expect. And then we say it's de novo plus we give due consideration to the decision, and we have the recording available, and people can say, listen to, minute 23 and here's a transcript of it.
So de novo with due consideration to the record.
Okay. The record.
To me, it sounds like hybrid.
Well, there's two different things.
Which
okay?
I like. I agree with Alex on this.
Okay, but there's two different pieces that we're talking about. One is what evidence comes in or doesn't. Are we locked down on what happened below? And the other one is in terms of the decision that you're making. Are you what kind of discretion do you have? Is it just completely new? You are not bound by anything.
Right.
Those
That's
are the
what de
two.
novo means. But
Yeah,
in terms of the record, giving it due consideration, I think that is, Alex, go ahead.
So my thinking can evolve even in one meeting. And I do, like I said, I'm a little worried about the burden that requiring a municipality to provide all of the evidence they took in, may be hard. But I don't like, so what bothers me about de novo the most, Brooke, are two things. One, that the decision of the body is not automatically considered and entered into evidence in some way and given due consideration. And I think we're all on the same page that it should, right? But then the question is it still a hybrid or is it de novo? The second part that bothers me about de novo is that the appellant, if they're the applicant, can present variations on the project to maybe try to address some issues. It doesn't have to be the same project that the body below that was being appealed actually reviewed. I hate that. I don't want
Yeah.
that to be the case. So that's where I like hybrid, because it says it has to be the same project. We're looking at the same evidence. We are going to give due consideration to the lower board's decision. And if you have supplementary evidence that you want to provide to help make your case on particular questions of the appeal, we will accept that. That's what I like about it. So if you can thread those needles, that's what I'm looking for.
All right, what I don't like about this hybrid standard is it will give rise to arguments and motions about, oh, you didn't let this in and it should have come in. Oh, you let them have that and we didn't get to respond to it. That's why I like de novo, because it's simpler and cleaner and gives rise to less legal mumbo jumbo. I hear what you're saying, and I think we are accomplishing the same thing, because we are, look, it's about, we're making an independent decision. We were going to do that anyway. And what this does is it, instead of having to ask for permission to put more stuff in and having issues arise from that, they can put in whatever they want.
So can
And
we
we will-
require
we-
that it's the same project?
Oh, yeah. And on that
Yeah.
issue, we don't, and Jenny, speak up if I'm not articulating this accurately, but, you can make, if you're in the environmental division, you can make, tweaks that are not, that wouldn't be considered, a substantial material change to the project. But if you all of a sudden say, well, we're going to build a, 5-bedroom house, not a yurt. We don't have
So-
jurisdiction as an appellate body. And
Right.
so we don't have to write that into rules. We can just say, I'm sorry, you're in the wrong place. If you want to change it to that drastically, you got to go there first, because the tribunal below has to have first crack at it. We're only an
Yeah.
appellate board.
Yeah.
So I hear what you're saying. Absolutely, Alex, but that's an implementation of our process. We cannot exercise jurisdiction over something we don't have the ability to.
Okay. Any further discussion today, Kirsten?
Well, I was just going to echo Alex's concern about requiring that every municipality would be responsible for supplying the record, and in particular, the challenge with transcripts as we know it. So it makes sense to receive a copy of the recording, but whether or not on appeal, the recording, what is the role of that evidence as part of the appeal consideration? I think that it should be prescribed that if there's important oral testimony or information in the recording, that the party wanting focus on that testimony should create the transcript or somehow identify, as I think Alex might have suggested, like at minute 34, listen to, the next 10 minutes and the following statements, like something like that. And I do think it's the parties who bring forward the appeal that should obtain that record from the town. Obviously that will require some collaboration with town officials to transfer that information into their hands, but
Actually, it's not, I mean, it's public. It's on their, it's required to be on their websites. We can just get it from the website. So can an appellant or an appellee. So I think we can just ask that they do that without bothering the town at all, unless there's some problem on the town's part with providing that to the public, and in which case it is the town's responsibility. So to get it to us.
so your understanding of current municipal law is that it must be posted on the all towns' websites?
Yeah,
Okay. For the towns that qualify for the waiver of the hybrid meeting requirements, they don't have the recording to the same
There is no
format. I think we
recording.
need to make sure that we don't create a requirement that's in conflict with that circumstance.
I mean, they'll
So-
have minutes that are required, in any case. So,
Yeah, my thoughts on the transcript and what happened at the hearing. I think that we ask for the recording to be sent. I mean, the appeal gets filed with the town anyway. They know that it's being appealed, so they should have a responsibility to just deliver the recording to us, because we don't want the recording from a person because of like chain of custody or whatever. We want it directly transmitted from the town to us. And I don't want to have to go looking on, websites or relying on parties. And once we have that, I think what we do is we say, if you want testimony from the record below, from the hearing below, to be entered into the evidence here, you have to transcribe that section and file it like pre-filed testimony under oath. This is what was said, and if somebody has an issue with what you heard and put on the piece of paper, and this will be done from the transcript, right? That's automatically created by YouTube. Well, that's assuming they're going on YouTube, and I'm not positive that they have to post that, but they will have the recording regardless, right? So if we give that as a piece of potential evidence that people can extract from and say, hey, here's a paragraph that somebody said and I want that entered into evidence, they have to present it to us as, I listened to this is exactly what was said that I heard, put it into evidence, and then other people could say, no, they didn't say that. I mean, I think in terms of dealing with it as actual evidence, that's probably the way you put the burden on others. You want us to know something was said, you have to present it. And we can always go back and listen if we want.
okay. Okay, Brooke, do you need anything else from us before?
I think I'm good. And so plan then, I will get a new draft to everybody by Monday. We'll get it posted on Monday. Or maybe, are we going to talk about this on Monday?
Yeah.
Okay, so I'll get it to you by Monday morning. We'll get it posted, and then we will plan probably on Thursday if we're having that meeting on the 20th.
Yeah, I think we probably will be having that meeting on the 20th.
And if we can get it approved then, otherwise we'll push it off till the following Monday. Okay.
Just to mention, Janet, there's another one of the permit modernization meetings that's scheduled to go until 1:30 on the 20th. So the board meeting on the 20th might want to
Oh,
have
yeah,
it started a little later,
Two.
1:30 or 2.
two, yeah, that's good catch. Thank you, Kirsten. Yes. Okay, so let's move on to the next agenda item. Discussion of appeals and enforcement. Oh, no, discussion of attorney-client communication. No appeals and enforcement today. Do we have a motion?
I'll make the motion that to go into executive session to have communications with our attorney.
I'll second it.
Thank you. Any discussion? Okay, all those in favor, please say aye. Aye.
Aye.
That is unanimous. So we will go into executive session and report back out before adjourning. We might not have anything to report back out, however, so see you in a little bit.
Recording.
Okay, we are still recording. And we will bring the prioritization, the housing prioritization policy to our Monday meeting for a vote. Correct? Is that what we determined? Okay. Okay, thank you, everybody. And we have one thing left to do. Kirsten,
I'll make a motion to adjourn.
thank you.
No.
Sarah?
I'll second.
Okay, thank you. All those in favor, please say aye.
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 Thank you. That is unanimous. See you all. Rebecca,
Safe travels, Brooke.
Yeah, I'm still, yep.
I'm gonna try to hook up with you.
Let me stop our recording here.
Okay.
Yes.
There we go.
Yeah.
Sorry,